The Senate Judiciary Committee will come to order. Before we proceed, a letter from the Senate President pursuant to Rule S3-2C. I hereby appoint Senator Bill Cunningham to temporarily replace Senator Mike Halpin as a member of the Senate Judiciary Committee. This appointment will expire upon adjournment of the Senate Judiciary Committee on March 25th, 2026. Sincerely, Don Harmon, Senate President. Madam Clerk, please call the roll.
Senator Hills? Here. Senator Curran? Here. Senator Tracy? Senator Sims? President Harmon? Here. Senator Halpin? Senator Fine? Here. Senator Martwick? Chairman Hastings?
Here. Madam Clerk, please call Senator Cunningham for attendance purposes.
Senator Cunningham.
There being 8 members present, a quorum has been established. Paul Elders and Paul Elders and Greg Bishop with Blue Room Stream Media request permission to video live streams. Do we have leave? Leave has been granted. The following bills will not be heard today: Senate Bill 3609, Senate Bill 3777, Senate Floor Amendment number 2 to Senate Bill 3251, and then Senate Bill 3812. The following bills are on the agreed bills list: Senate Floor Amendment number 1 to Senate Bill 3291, Senate Floor Amendment number 1 to Senate Bill 3196, Senate Floor Amendment number 1 to Senate Bill 1573, Senate Floor Amendment number 1 to Senate Bill 3524, Senate Bill 3527 with Senate Committee Amendment number 1, which was adopted in subcommittee. And the following bills will be heard today: Senate Bill 3750 with Senate Committee Amendment number 1 and Senate Bill 3401. Those will be heard today as well. We're going to do some agreed bill list formalities here. Senator Fine moves, recommend do adopt to Senate Floor Amendment number 1 to Senate Bill 1573. Do we have leave? Leave has been granted. Senator Fine moves, recommend do adopt Senate Floor Amendment number 1 to Senate Bill 3524. Do we have leave? Leave has been granted. Senator Fine moves, recommend do adopt Senate Floor Amendment number 1 to Senate Bill 3291. Do we have leave? Senator Fine recommends do adopt Senate Floor Amendment number 1 to Senate Bill 3196. Do we have leave? Leave has been granted. And those will be, leave has been granted, and those bills will so be reported to the floor. The amendment to Senate Bill 3527 was adopted in subcommittee. Senator Fine moves that Senate Bill 3527 do pass as amended. Is there leave? Leave has been granted. That bill will be reported to the floor. Now on to the substantive business of the committee. We will start with Senator Fine, Senate Bill 3750 with Senate Committee Amendment number 1. We'll let the system update so we can read the witness slips. Senator Fine requests permission to present from her chair. Senator Fine, on your bill, and once the system updates, we'll read the witness slips into the record. Senator Fine, on your bill.
Thank you, Mr. Chair. This legislation is an initiative of the Guardianship Advocacy Commission, and it clarifies definitions and procedures in the Mental Health and Developmental Disability Code. And with me today, I have Tony Rothert, who's General Counsel of GAC, and Veronique Baker, the Direct Legal Advocacy Service Advisor. And I would welcome them to state their names and their positions.
Before you do that, there's 3 proponents, and that being the Illinois Guardianship and Advocacy Commission, which will provide oral testimony, and there's 3 opponents that have only filed for appearance only, which means they don't wish to give oral testimony. Sir and ma'am, if you don't mind, for the record, please state your name and provide your testimony.
My name is Anthony Rothert, and I am General Counsel for the Guardianship and Advocacy Commission. This bill updates key definitions in the Mental Health and Developmental Disabilities Code to reflect today's clinical and legal realities. Right now, the term admission is not defined in the code, leaving the meaning of admission and discharge to be interpreted through court decisions. The result, as the Illinois Supreme Court warned in Andrew B., is that an individual may be confined indefinitely in a mental health facility without ever receiving a court hearing. That's a problem that the court said, quote, deserves the attention of the General Assembly. What the court warned of happens routinely, but this issue has not yet received the General Assembly's attention, and thank you, Senator Fine, for initiating this discussion. The bill also closes a loophole that has forced some individuals to receive electroconvulsive therapy without consent and without a court order, and it removes an arbitrary differences in rights solely based on whether someone has Alzheimer's versus Parkinson's. Finally, the bill modernizes testimony rules, allowing advanced practice psychiatric nurses to testify in involuntary treatment cases, and recognizing that individuals may be able to consent to some, but not all, of complex treatment plans. Together, these changes will reduce confusion in care transitions, improve responsiveness to clinical needs, and ensure that involuntary treatment, when needed, begins promptly, all while restoring essential due process protections that to place a check on the government's ability to take away one's liberty.
Ma'am, if you'd like to provide testimony, please state your name for the record.
Good afternoon. My name is Veronique Baker. I am the Director of Legal Advocacy Service. It is a division of the Illinois Guardianship Advocacy Commission, and I've served in that position for the last 19 years. LAS attorneys represent respondents in civil mental health cases across much of the state of Illinois, and we handle a vast majority of those petitions. Our experience shows recurring problems that this bill is designed to address. We routinely see respondents repeatedly petitioned after the case has been dismissed instead of being released, or held for days on drafted but unfiled mental health petitions, preventing them from getting prompt legal representation. We also encounter involuntary treatment cases where incomplete testimony prevents the judges from authorizing necessary treatment. This legislation clarifies key terms, ensures petitions meet the burden of proof, and expands who may testify as an expert so that professionals with firsthand knowledge can provide complete information. We believe the changes will better protect the civil and constitutional rights of recipients navigating the mental health system. Thank you, and I am available for any questions.
Do we have any questions? Senator Tracy has a question.
As I understand, the latest version of this bill allows this kind of treatment based on the recommendation of a psychiatrist or an advanced practice nurse. Is that correct?
The amendment that was just adopted would change psychiatrist to physician, so it would be physician and advanced practice psychiatric nurse.
But as I understand, it says or, so it can be
Or, yes.
or. So that's what I wanted to clarify is what kind of certification does an advanced practice nurse have?
Advanced practice psychiatric nurses have extensively more education and training, specifically with people living with mental illness. They are usually the people who are intimately involved with our clients, so that when they come to court and testify as the expert, they've had the interaction with our clients, they know our clients a little bit better, and it provides more complete testimony so that the court is in a position to make a decision regarding case.
Thank you. And I'll admit, this is an area that I'm not very well versed in, and I'm just concerned for me, it seems like we're making, you say it clarifies definitions and actually makes it easier for the patient to get the services they need. I'm worried about the patient that doesn't want these services and overriding their wishes. Am I correct in that? Does this bill do that?
No, this bill actually does not override their wishes. We've already got a system that allows for involuntary commitment and involuntary treatment. What this bill actually does is try to set some hard and fast definitions on when confinement begins, so that that triggers when mental health petitions have to be filed. It also triggers the respondent being able to have an appointed counsel, and there's a host of other rights that go along with that. Without having a hard and fast rule on when confinement begins and when discharge means a physical release, what happens is people are continuously held in hospitals without ever getting to a complete hearing on the merits of the petition.
Senator Tracy, my name is Tanika Jennings. I have a witness slip-in as well, Director of Legislative and External Affairs with the Illinois Guardianship and Advocacy Commission. I always get distracted by my own voice. One thing I wanted to mention about the specific piece that you asked about with expanding to advanced practice psychiatric nurses, from our experience, the specific provision of this bill has wide support, including from the Illinois Psychiatric Association, as well as other state agencies like the Illinois Department of Human Services, and across the board, the folks that we've been talking to who practice all are in support of that, if that is helpful.
And also, I wanted to ask, there is opposition to the bill, and I was inquiring about the opposition. I think the Hospital Association is concerned about the 24-hour time frame. Could you elaborate on that, and why it's necessary to make it 24-hour?
Yes. Currently, the law says that you can hold someone involuntarily for 24 hours, and if you want to hold them longer than that, you have to file a petition and a certificate. In practice, that doesn't happen. And instead, the person is held on a late petition, held illegally, until there's a hearing a week or two later. Then the petition is dismissed, and they're ordered discharged. But you don't have to release someone to discharge them, according to the Supreme Court. So the person's kept still on the psychiatric floor, and a new petition is started, and the process starts all over again. So that allows a person to be held against their will for weeks without ever even having a hearing. So we're trying to restore due process.
Okay. Is there perhaps a medium ground that we can meet that would meet what their concerns are about the 24-hour period, so that they feel like they could actually carry it out within an appropriate time frame?
We are in discussions, and I think there are routes to resolve this.
Okay, thank you for that information. Thank you.
Just a couple, just clarifying questions. Advanced practice psychiatric nurse is required to have 4,000 clinical hours, is that right?
I believe you're correct.
And then they have to have 250 hours of continuing education or some sort of rounds and additional training within their role, is that right?
That's correct.
And then they're able to, once they reach their AP PN position or certification, they're allowed by law to conduct tests and assessments of patients, is that correct?
Correct.
Okay. And then they're able, under full practice authority, to prescribe medicine, is that correct, under supervision?
That's correct.
Thank you very much. Any other questions? Senator Fine to close.
Thank you. I would ask for your support for this legislation. I know the Hospital Association continues to work on this with us, and my note from Dave Gross says they are okay with us moving this out of committee and continuing to work on it after that.
Motion has been made, do pass as amended by Senator Cunningham. Do we have leave?
One for the question. Is my understanding that the State's Attorneys Association or the Cook County State's Attorneys Association are still opposed?
As per the witness slip, Senator Tracy, Dave Gross from Illinois Health and Hospital Association, Mr. Ambrose from the Cook County State's Attorney's Office, and Mr. Willie White with no organization, all filed for appearance only. So those are the only records we have in the system.
They are also involved in our negotiations.
Yes, we're having very good conversations with the state's attorney's office as well, and we're working on some potential draft
Okay.
language.
Are you anticipating an amendment?
It's possible, very possible, yes.
Okay.
So-
I would just ask Senator Fine if you're willing to bring this back to committee with an amendment. I mean, we would give you leave, but if not, we would want the concerns addressed before we would vote in favor.
And that's not committing to an agreement. That's just saying you're going to come back to the committee with an amendment.
That's fine.
Senator Fine, with representation of coming back to the committee with an amendment, but not on an agreed amendment, she will come back to the committee based on that agreement.
And then there's leave.
We have leave. Leave has been granted. This will be the bill will still be reported to the floor and come back to the committee with the amendment. So, thank you very much. Thank you. I'm going to yield the chair to this Mr. President, and I apologize, Senator Sims, but I will present from the table.
We're going to turn to Senate Bill 3401. It's sponsored by Senator Martwick, but Chairman Hastings is going to present it today. There are 5 proponents. The Community Associations Institute and the State Bar Association are both in favor. 1 opponent, the Illinois Realtors. No filing, no position on the merits. So, Senator Martwick, please proceed. Senator Hastings on Senator Martwick's behalf.
Thank you, Mr. President. Members of yeah, I know, that's for sure. My shoes aren't shined like this. This amends the Condominium Property Act and Common Interest Community Association Act. This bill requires a common interest communities and condominium associations to conduct a reserve study. The purpose of the study is to analyze reserve funds that may be required for future maintenance, repairs, and replacement of common areas. In particular, the bill provides that any community or association that has a reserve study completed on or after January 1st, 2024 must have an updated reserve study conducted within 5 years from the date of that study. And any community or association that has not had a reserve study conducted must have one conducted on or before the 1st of January 2028. It must update the study every 5 years to assess the condition of common areas. The bill exempts associations with 15 or fewer units from this requirement. And Mr. President, we've had extensive conversations for about a half hour, 45 minutes prior to this committee as to the substance of this bill. I ask for an aye vote.
I know you have some proponents. Do they wish to testify? Proponents first? Anyone? That's right.
Thank you so much. Try not to be as loud. My name is Pat Costello. I am an attorney who works for a law firm, Costello, Surrey, and Rooney. I am also the co-chair of the Legislative Action Committee for Community Association Institute of Illinois. This is a bill that we have introduced in some form or fashion for the 3rd time. After the first bill was introduced, there were concerns raised by one of your Senate colleagues. We went back and we redrafted certain provisions in the bills. One of the things that's critical about this bill is we are asking for associations to study their major components, to review what the costs and expenses associated with replacing those and figure out what the life expectancy of that. Part of the reason why that needs to be done is, especially in the Illinois Condominium Property Act, there is already a mandate that board of directors reasonably fund their reserves to deal with capital expenses in the future. However, there is no mandate that a reserve study be conducted. There is a requirement in the Condominium Property Act and in the Common Interest Community Association Act that reserve studies must be turned over to owners who request a copy of them. There is no requirement in either act that a prospective purchaser is entitled to receive a copy of a reserve study. So we have this missing component. They're required to fund reserves, they're required to advise their owners, but prospective purchasers in an association may be completely unaware of what that reserve study entails. So we've also included in the statutory sections that this be added to the disclosure. I bring that to the committee's attention because we do really see this as a consumer protection bill. Somebody can come in to an association and say, oh, we have $1 million of reserves. Great, sounds like a big number. Not if you have $20 million of deferred maintenance obligations. That's problematic. And what happens in those situations? We see new buyers, we see less sophisticated buyers, we see young buyers buying in communities, and they think, oh, my dollar assessment is this much a month. Well, 12 months down the road, maybe the roof failed, maybe the wall failed, maybe balconies are getting tagged by the municipality because they no longer meet code. And now what are they going to do? Well, the first thing you should do is look towards your reserves and say, do we have sufficient reserves to replace the roof, to repair the balconies? But what if those reserves haven't been funded with any type of knowledge, and it's just 5% a year of the budget, but it's unrelated to what the needs will be? So now that new buyer who, having been a new home buyer myself at one point in my life, you can pay your mortgage, you can pay your assessments, you can pay your insurance, and eat at McDonald's for a couple of years because that's what you can afford. And you don't have that extra funds that a special assessment could set you back. And so people are buying into these communities unaware of what could possibly happen in the future. Not to make a social commentary here, but condominium and homeowners associations are no different than the rest of our country. Our infrastructure hasn't been kept up, unfortunately. And when you put that on the back of individual owners in their homes, it's no longer a choice whether or not the roof needs to get replaced. It was brought up in subcommittee. There is a condominium, a 5-story condominium building in Morton Grove where 2 of the floors collapsed several weekends ago. I guarantee you they did not have a reserve study in place. I guarantee you they were not unaware. So now you have a building, 5 stories of people who don't have a place to live. Insurance isn't going to cover those types of defects. So now you're going to individual homeowners and saying, we need you to pay money to rebuild this building that you currently can't live in. I don't know where those funds come from for most people.
I think we have the bill fairly well stated. Does anyone have questions for the proponent before we open it up to an opponent? Senator Fine?
I do. Thank you. I understand the reason why you'd want the study in place, but something we discussed in the subcommittee, which I really would like more clarification on, is there any certification or a license for the people who do these studies? And in the case of Morton Grove, where you just brought up, is it the condominium association that's responsible, or is it the insurance that's responsible?
I don't know of any insurance policies that cover what is construction defects or lack of maintenance. Insurance policies typically cover what's defined as loss under the policies, and the floors collapsing unless there was a tornado or a storm like that that hit, it isn't going to be in place. But to your question about licensing, part of the reason why we amended the bill to remove the requirement that it be a licensed professional is one of your colleagues said, we're concerned about the potential cost for these things. Even at $3,000, $5,000, $6,000, we're concerned about the cost. So we went back and we revised the bill to say, if you follow these standards, we're going to define what you need to look at, we're going to define what you need to evaluate, we're going to define what you need to do. So how would a board do that? You'd call a roofing contractor and say, how long's our roof last? What's it going to cost? You'd maybe call a tuck pointer, have them come out and give you a bid. You'd call a concrete person or an asphalt person. This information is ascertainable from contractors, and then it can be built in. So the cost of these studies under the language of the bill could be zero. It can be conducted at a very reasonable level. I also think to myself, $3,000, $4,000, $5,000, just an example. I don't know if I'm uncommon. Every year I have an HVAC company come out and check my air conditioning unit and my furnace. It cost me about $400. I love air conditioning. I don't ever want to lose my air conditioning in the middle of summer. So for $400, I get assurance every year that my HVAC system is running, or if there's a problem, they'll tell me, hey, in 2 years, you're going to need to replace the condenser or replace these things. And then I can build that in. When you talk about even a, let's say, $3,000 expense for a 20-unit condominium building, this is once every 5 years. So 3,000 divided over 20, I'm a lawyer, I'm not a mathematician, and once every 5 years. That's a de minimis amount of money to obtain that assurance as to when these costs and expenses are going to be incurred. So the cost can be as little as $0. Can it be more than that? Sure. Who performs these studies when you go to third parties, Senator Fine? Engineering companies and architects. They are already both licensed. That's the people who typically do these types of studies because they know the life expectancy and they have an idea as to the costs and expenses associated with repairing these items. But we're not asking that it be required as licensed person out there. I will point out that there was a lot of talk in the subcommittee about, well, how will this affect smaller associations? And I would like to make a bit of a distinction. The Common Interest Community Association Act already exempts every community with a budget that's lower than $100,000. So if you're a single-family homeowners association with about 50 homes and you don't have a $100,000 budget, this doesn't apply to you at all. So it will apply to every condominium association that's 15 units or less. I live in a 4-unit condominium building. We have an elevator, we have a roof, we have all bricks, we have a heated garage. We should have a reserve study. Now, part of the concern was this will be too expensive. And yeah, would $3,000 be expensive for our 4-unit building divided amongst us? Sure, it's not an anticipated expense. But that reserve study is something I can give to a prospective purchaser when they come in, and they can have certain levels of insurance of, okay, what are my costs and expenses going forward? But I do think the totality of the expense with that assurance is pretty important. And I do think there's a little inconsistency. If the worry is that there's going to be these fly-by-night unlicensed companies out there, okay, then go get it done by a licensed company. But the other concern that I was hearing was it's going to cost too much if we do it by a licensed company. I don't know how to balance those two things together. Now, if you're going to hire a professional to do it, and if I had a client ask me what my recommendation would be, sure, I'd want them to hire a professional for 2 reasons. One, I hope the professional would have more qualifications. And 2, and this came up a little bit in our subcommittee, it's a way to shift liability too. So if you have it done by a professional third party, then the board of directors could say, we contracted with a professional licensed engineer, and they said this roof was good for 20 years. It was only good for 2? Now somebody we paid to actually conduct this study, we can look back towards them if that information was incorrect.
Okay. Yeah, I'm just concerned about A, liability. I brought that up in the subcommittee, and B, fly-by-night studies, because especially when you talk about the mom and pops who want to get it done and think they're getting it done right, how could the new buyer be assured of the stability of the study?
Thank you.
Just out of curiosity, would a standard reserve study reveal a construction defect that results in 2 floors collapsing?
It might, in that case, probably because some of the beams were defective downstairs, is what we've found out from the media reports. So it would have been something visually that could have been inspected. But, President, to your point, it's a visual inspection. It's not a forensic engineering study. And that's why it doesn't cost hundreds of thousands of dollars typically.
Other questions? Why don't we hear from the opponent? Ms. Carter, did you want to approach we'll excuse the proponent and invite the opponents up.
Thank you.
Thank you. My name's Malia Carter, and I'm the Vice President of Government Affairs for the Illinois Realtors. I'm here today to express our concerns with Senate Bill 3401. We did bring this bill in front of our policy group, which consists of our realtor members, and there were a lot of concerns about the costs of the studies. There was some concerns that some of the studies are very expensive. They could certainly result in special assessments just to fund the study. There were also concerns that this could lead to the rise of fly-by-night reserve study companies looking to profit off of the bill. And also for the smaller HOAs and condo boards that maybe are bigger than 15 units, but they're still considered small HOAs and condo boards. They might not have the resources for this, and especially outside of metro areas, there could be even less standardization and less availability of reserve study companies that are actually qualified to do this work. So the underlying issue here is let's get a handle on the costs. One of our biggest concerns right now is that there's a crisis in the housing market. This crisis is mainly because of a lack of supply. And the more fees and this week we've been battling fees, back in the House, and fees for energy audits and things like that. And every time we add these additional costs, it exacerbates the cost of housing and the availability of housing and the supply of housing. So we want to make sure that any policy that we're putting in place doesn't exacerbate that problem. Right now, we're looking at about 146,000 units, housing units, short to fulfill existing demand, 225,000 in the next 5 years. And that's just for the existing demand. That doesn't even take into account people moving here or anything like that. So I think it's a big concern to ensure that we're not doing anything that would harm the supply, because every time we add fees and mandates, we're driving developers, we're driving landlords, we're driving housing providers out of the market and into potentially other states. So that is one of our biggest concerns. Also, just to note, today there's no prohibition from these condo associations from doing a reserve study. They could do it today, and we're not saying that having structural assurance of a property is not important, but if you're a smaller association and the roof is bad, and I know it's going to cost $3,000 or $6,000 to do a reserve study, wouldn't I rather put that money in the cost of replacing that roof than a study? So for those reasons, we do have some concerns. We are willing to keep talking to the condo association people to see if we can work through some of those things. But today, as it stands, we do oppose this piece of legislation. Thank you.
Thank you. Questions for the opponent? Senator Kern?
On the cost issue, I think as was testified by the proponents, the board itself can do it. So I don't see it as a mandate on an expensive study. It certainly could be used as an excuse by a board to justify an expensive study. I know you're going to keep talking. I appreciate the condo association coming in today and discussing it. At this point, like, I'm going to be voting in favor to move it forward, but I do want to continue to talk to you about costs, and I know you're looking into some studies in the past that may have been exorbitant in cost, and I really look forward to that answer and circling back on that before, hopefully before we take a final action on it.
Yeah, no, we appreciate that. I think part of the concern is that if I'm a smaller HOA and I'm told I have to do a reserve study, it makes them more susceptible to fly-by-night companies that may be coming in and trying to profit off this because they don't have the expertise to know what to do. I think some of your bigger units, obviously, they have their own in-house engineers and things like that, so they're in a little bit different place where they might be able to save on costs, but I think there's a lot of questions here still, so.
Further discussion? Is there a motion? Senator Sims? Senator Sims moves we recommend do pass Senate Bill 3401. Is there leave? Leave is granted and the bill will be so reported.
Thank you.
Senator Hastings?
There being no further business, Mr. President, before this committee, the Senate Judiciary Committee is hereby adjourned.
We'll tell him you're a better him.
Okay.